Um, Thank you very much for inviting me to be here to share in this exciting day. This is my first time at the 17th Annual IP and Social Justice Seminar, but I do spend a lot of time up in Boston thinking about IP and social justice. And I really can't think of anywhere better to share the historical work that I've been doing about patents and civil rights, particularly since this history is, like so much history, in part a Howard history, and we'll get there in a minute. Now, we all know what history is, right? It's the past. What happened back then. I'm a big fan of history, and I bet you there's a few history buffs in this room as well. But in my remarks today, I want to convince you that what I'm going to introduce as a piece of antebellum patent law is also part of the post-emancipation civil rights movements in the United States that, as Professor Matima just stressed, are continuing and is relevant today to the project of shaping IP laws, institutions in ways that advance social justice, that is, to our work as lawyers. What I learned from the past is that participation by African Americans in the patent system has consequences, not just in terms of access to these tools of individual economic empowerment, although that is an important consequence, and that's one of the social justice issues at stake here, but also in terms of the perception of a collective ability, inventiveness, in ways that influence questions of equality in the civic sphere, as well as in the technological and economic spheres. Patents issued to black inventors in the past were used as political facts to support civil rights campaigns, and I'm arguing that they remain political facts relevant to equality claims today. So this is what I'm going to try and sell you on. And I'm going to start by introducing you, as I said, to this Attorney General opinion from 1858. That's something that's not usually taught in law schools, but has long been remembered by African American activists seeking equality under the law. And then I'm going to give you a few examples of how those activists use patents as political tools in order to shift public perceptions about African American ability. And then ask why, right? Why patents were useful in this way, and then return us to the present in terms of our project today and our work as intellectual property lawyers today. So, starting with the past, this is in 1858, the U.S. Attorney General issued this very short opinion. I can put the whole thing here on this slide, and it's formally titled Invention of a Slave. The AG had been asked to review a decision of the patent examiner to deny a patent to an invention of an enslaved blacksmith known only as Ned. Not because the invention, which was to a new form of plow that was evidently particularly useful in preparing fields for planting cotton, which was the cash crop in Mississippi where Ned lived. Not because it wasn't a new invention, but because of Ned's legal status as human property. And of course, if you don't know the story already, you're not going to be surprised to learn that it was not Ned who applied for the patent, but Oscar, the white plantation owner, lawyer, and enslaver who was demanding that the patent be issued to him, Oscar, in his name as the inventor, claiming that the law of slavery gave him full ownership of the fruits of Ned's mind as well as the labor of Ned's hands. The Attorney General agreed with the patent commissioner that Oscar could not get the patent as the inventor because he was not the inventor, right? That's a matter of patent law. He couldn't swear the oath of inventorship. And that Ned could not get the patent either because he was unable to swear an oath either of inventorship or of citizenship under both the law of slavery, and the most recent Dred Scott decision had just come out the year before denying birthright citizenship to all African Americans. And once you start bringing Dred Scott to the equation, then the same reasoning that says that Ned, as an enslaved inventor, cannot patent his invention, it's also now barring free African Americans from the patent office because under Dred Scott, they are also not citizens. So while Oscar was mightily annoyed, he didn't get the patent that he wanted, although he didn't give up on his attempt to commercialize Ned's invention, which he named after himself and started advertising for sale. He did succeed through this opinion in creating, for the first time, a formal legal bar to patents based on race in the United States. Now, many of you probably also know, of course, that Ned wasn't the first or the only African American to invent something patentable in the antebellum period. Here's some other examples. The man on the left, James Fortin, invented a tool for managing sales, and his best sales as an S-A-I-L-S. Right. This is the 19th century, not the 21st century. He made a lot of money on sale management tools. You can make a lot of money on sale management tools today, too, right? But you have to spell it differently. As far as we know, he didn't receive a patent, although it's never quite clear because the patent office kept burning down in the early part of the 19th century, so we don't have complete records. The man on the right, Thomas Jennings, is the earliest known African-American patentee, and I have to stress known, because there may be others earlier that have not been identified. And here's another one, Benjamin Montgomery here on the left, who was also a skilled artisan enslaved in Mississippi, and his enslaver, too, tried to unsuccessfully patent his invention. And you might see that his enslaver's name, Joseph Davis, is the same last name as Jefferson Davis, future president of the Confederacy, and Joseph tried to get his brother to help him get the patent through, but he also ran into the same problem that Oscar did. So 1858, this opinion issues, and a lot is happening in the United States in 1858, and within a decade, this opinion is rendered legally obsolete, right, by the legal changes that follow the Civil War, overruling Dred Scott, abolishing the law of slavery. Now, we as lawyers don't really waste our time learning about overruled decisions, right? We call them bad law. We separate things out into good law and bad law, and we focus on the good law. But into my research into the history of the United States patent system, I've learned how much work there has been in the African American activist community to keep the memory of this opinion alive. It may not be relevant to the practice of patent law. Thank goodness it's not relevant to the practice of patent law, but they saw it as relevant to fights for legal equality and the citizenship rights that those Reconstruction amendments promised. Well, I've listed out in this slide 3 things that I think that is being remembered when you remember this piece of obsolete antebellum law. One is that there have always been inventive African Americans. The one thing that Oscar ironically managed to do in this fight was to give us the story of Ned, to give us the story of this man who was doing something creative with his hands in a way that his story might otherwise have been lost. Secondly, that there are uncountable, and really literally uncountable, not just countless, but uncountable numbers of African Americans who either never made it to the patent office or somebody else took their idea and made it to the patent office and made it their own. And the third thing that may be less obvious to us today that I think we're remembering when we remember Invention of a Slave is that patents have always been tied to citizenship and a recognition of a worthy contribution to the polity. And as I said, that doesn't seem terribly obvious, at least to me sitting in the 21st century as I was thinking about this, but it was very obvious to the generations of African American activists who not only remembered this opinion, but worked hard to identify African American patentees, a very difficult task given the lack of any racial identification in the records of the Patent Office, and then to publicize all the ones that they were able to identify. And they were making this effort in order to support claims in their time, whatever that time was, over the many decades between 1858 and now, in support of full civil rights claims. There are many participants in these efforts, but I want to highlight just one of them who, and this is the Howard part of the story, a Howard alum whom I hope that everybody who studied patent law ever at Howard University knows about. Howard Baker, who was one of the first, if not the first, African-American patent examiners. Baker was born in Mississippi in 1857, the same year that Ned came up with his plow. He was educated during Reconstruction. He moved here to D.C., and one of his contemporaries said this about him, that he was connected with almost every well-directed movement looking to the betterment of his race. And Baker took inspiration from Ned's story to use his position in the patent office to collect evidence of as many African-American patentees as he could, and he had to do that relying on memory, right? There's nothing in the records. He had to ask people in the office, he had to ask the patent bar, have you ever heard of an African-American inventor that maybe you helped apply for a patent? Could he match the memories to the records in the office? And what I want to point out here what is sometimes lost in our enthusiasm to uncover these lost stories of black inventors, because it's exciting to uncover them, and that work is still going on. Patricia Carter-Slubby, another former patent examiner, she's now retired, has really worked on, in the last several decades, to expand Baker's list and bring more of these stories to light. But I want to point out that these aren't just lost stories. These are directly related to Baker's efforts on behalf of what his contemporary called the betterment of his race. Here's Baker in DC, in these decades, often known as the nadir of race relations in the United States, and he's seeking to combat the arguments of scientific racism that are being used to justify Jim Crow, white supremacy, and the denial of legal, social, and economic equality to African Americans. Facing arguments that African Americans are biologically limited in ability, right, that's the argument of scientific racism, those who were working for the betterment of their race sought to prove inventiveness as one of the many abilities that they supposedly lacked. And in that way, patents then granted to African Americans, if you could identify them, were not just historical facts showing that there was a black inventor at this time who invented this thing, but they're political tools. And African American activists used Baker's research to mobilize the tools. They put models of patented inventions on display before white America at the World's Fairs that were held in the United States. This is a picture from the New Orleans Fair in 1884, which was the first U.S. World's Fair that was held in the South, and the first to have a space that African Americans could curate themselves to show their own exhibits. In 1894, the man there on the right, George Washington Murray, was a representative from South Carolina, and he took the opportunity to put Baker's research into the congressional record. He read all the patentees that Baker had been able to identify at that time into the congressional record. And he did that as part of debates about whether the federal government would fund the next Southern World's Fair, which was the Atlanta States Cotton Exposition that was held in 1895. And look what Murray said when he was arguing about this. He says, we need to have this exhibition, and we need to be able to show these patented models. And Murray's somebody who has received 6 patents himself. He's an inventor himself. Because he wants, he said, the white audience is coming to the fair to appreciate the fact that the colored man is coming to a share in the government of the country. Notice he's emphasizing political participation with the use of these patents. And with Murray's urging and using Baker's list, the Patent Office did collect some official patent models of inventions that had been identified as patented by black inventors and sent them for exhibit in Atlanta. And here's another exhibit in Paris in 1900, a very small space that African Americans were able to curate there. They didn't have room for models, so they made paper copies of 350 patents that are up there on the wall so that everybody could page through and see the cumulative record of patents granted to African Americans. And Baker eventually published his research in a small pamphlet in 1913, and look who published it. It was published by The Crisis. It was an NAACP pamphlet. Right? The NAACP is not an organization that was worried about technological advance and promoting the progress of the useful arts, but they are, of course, interested in civil rights, and that's why they're focusing on this as well. Well, why? Why was the NAACP putting its money here? Why all this work to identify and publicize black inventors? Well, you know, everybody in this room knows already, right? Every patent is a certification by the federal government that that named inventor has originated something new, useful, and non-obvious, which these technically trained examiners have, in theory, examined against the sum total of human knowledge, right, in theory. And for people who are trying to overturn this common wisdom that African Americans can only imitate, right, that argument that's coming up through scientific racism, patents then are a really powerful form of rebuttal evidence, and a form that keeps increasing in quantity year after year. They've got 350 pieces of paper there in Paris. Because in Jim Crow America, the Patent Office was actually a rare locus where claims could be asserted and rights could be secured in ways that were both formally and practically race blind. I'm not saying that the federal bureaucrats were free from race prejudice, but as you all know, you can apply for a patent by mail or through somebody else, right? So that was one reason that patents were useful rebuttal evidence at the time. But there's another reason as well, and that's the reason that I was pushing you towards when I pointed out Murray's quote there about the share in the government. And it's more crudely told in this anecdote that Baker included. Do I have it? Here it is. That Baker included in his pamphlet. In the pamphlet he wrote, where he lays out all his research on black inventors, he says, here's this Maryland politician running for election, right here, in the first years of the 20th century, and his stump speech includes this assertion that the colored race should be denied the right to vote because no one of the race had ever yet reached the dignity of an inventor. This statement that African Americans could not invent, and therefore did not deserve the right to vote, drew upon a link between patents and inventive ability and citizenship that had been well established by 1858 in ways beyond that need to swear the oath of citizenship. In the early republic, white Americans had come to see themselves as a uniquely inventive people, and also had come to understand that quality, inventiveness, as directly related to participating in democratic government in the form particularly of voting. What do I mean by this? Well, since the Revolution, American elites had believed that citizens who participated in democratic governance required the capacity to think independently. As white men excluded other people from the polls and other citizenship duties, like jury service, for example, they justified that exclusion on the basis that the assertion of these others, non-whites and women, were incapable of independent thought. They were like children and the insane. They might be citizens, but they could not be voters, because voters needed to be able to think for themselves. Well then, in fighting against Jim Crow voting restrictions and this broader battle for civil rights, the reason that the NAACP was founded, patents had particular significance because the determination of you getting a patent is that separation between imitation and origination. Right? You have to come up with something new, and not just new, but non-obvious, more than what an ordinary mechanic can do. So they're demonstrating not only inventiveness, but independence of thought, to do more than imitate, but be able to originate, that Americans, white Americans, kept telling themselves that full citizenship required. So faced with arguments like this then, working to identify and count up and publicize how many African Americans had received patents over time was a sound political strategy, right? And this is why the NAACP was on board with this. So I've been arguing that patents are political tools because they were tied to this perception of the ability to participate in the civic space beyond their evidence of technological contribution and the possibility they offer financial return, and we certainly cannot put those to the side. Those are important as well. But I want to conclude by arguing this perception persists in our present, this perception, this relationship between patents, inventive ability, and American national identity, meaning that patents are still political facts in this way today. We in the United States like still to think of ourselves as a uniquely inventive people. We have a National Inventors Hall of Fame, right? And while nobody says that if you can't invent, you can't vote, that seems a little crazy to say right now, I think it does remain tied to our idea and our ideal of who the American citizen is. You notice the PTO runs these camps for kids to encourage them to invent, to grow up as good American kids being inventors. And I think, yes, we want more innovation. That's part of the reason the PTO has this, but it's also a way of teaching children what an American is, right? This ideal of Americanness. And I've been watching with great interest since 2016, as immigration has rather forcefully returned to our national agenda, that I'm finding scholars who are looking to document immigrant contributions to the United States by counting and identifying and publicizing how many patents have been granted to immigrants, right? And what's the stake there? Citizenship, right? We're repeating those sort of same arguments. So this political role for patents, which is still there, I think ups the stakes in the question of minority representation in the patent system. Moving the needle on patent rates is important for many issues related to social justice, but one of them is this link between inventive ability and perceptions of belonging. And this is what my co-panelist is going to be talking about, is the question of what those rates are and how we might move the needle in the present. So I'll turn it over to her. Thank you.
So we're bringing that up. Good afternoon. My name is Brittany Amadi. I'm a partner in the WilmerHale, Washington, D.C. office, where I focus on intellectual property litigation. So sort of coming off of Dr. Swanson's discussion of the historical significance of patents and how they were used as a tool, I'm going to follow that up by talking about some recent legislation that is directed to sort of increase, or the purpose of it is to increase minority and women participation in the patent office in order to obtain more grants for minorities and women. So I'll talk today. It's called the Success Act. So I'll first give an overview of the act, which passed a little over a year ago in October of 2018. I'll then talk about the report that stems from that act that was issued in October of 2019, a year after the act's passage. And then I'll talk about, just generally speaking, what's the way forward here? Now that we have this act, we have at least some sort of attention to this issue, and how can we use that, and where do we go from here? So I'll start by saying that although in the last year or so, Congress has not passed many bills and hasn't agreed on much, this one was an easy sell. It passed in the House in September of 2018. The next month, it was confirmed by unanimous Senate, and not long after that, signed into law. So what is the Success Act? The Success Act stands for the study of underrepresented classes chasing engineering and science success of 2018. So it's really organized. It's a very short act with two primary sections. The first sets forth the findings of Congress and the reasons behind this act, and then the second goes into what the directive is to the PTO. So up here on the slide, I've put an excerpt from the act, and basically there was a recognition in Congress that there was a significant gap, probably it's a surprise to no one, between the percentage of women and minority inventors who were applying for and obtaining patents in the patent office from their male non-minority counterparts. So there was a recognition of that, and there was also a recognition that it was beneficial to not just particular inventors or particular individuals or classes of society, but to America as a whole and the economy, in order to close that gap, to ensure that women and minorities were represented in the patent office, owning their inventions, having that innovation, which could spur stronger businesses, smaller businesses, as well as additional opportunities later in life. So the sense of Congress, just quoting from the statute here, was that the government has a responsibility to close the gap in the number of women and minorities applying for and obtaining patents. So the directive to the Patent Office was to conduct a study to identify what publicly available information and data there are out there on women and minorities who have applied for and obtained patents, and they actually expanded that to veterans as well, and then to make some legislative recommendations for how we can work to close that gap. The PTO was directed to work with the Small Business Administration in conducting this study and issue a report within 1 year of its issuance, and that report did issue in October of 2019. So the Success Act laid out the sort of why. Congress wanted to ensure that the United States remains a leader in the innovation space by helping small businesses drive, and recognize that diversity was critical to reaching that goal. But there was really no substance or meat there on the how, and how do we increase that participation by minorities and women in the patent office, both applying for and obtaining patents, as sort of a way to increase their footprint in the economy as well as in small businesses and innovation. So Congress delegated that sort of how to the Patent Office, recognizing that the Patent Office may have some unique expertise in these areas. The Patent Office, as it turns out, sought some expertise from others in order to assist with this process of coming up with a report and making recommendations to the legislator. So in April of 2019, the Patent Office published a formal notice requesting comments on 11 different topics, and I've sort of summarized them here on the screen. But the topics ranged from advising the Patent Office on where it could obtain the data required to issue the report that was mandated by Congress, to identifying the benefits that flow from having a diverse inventorship and a diverse innovators and patents with diverse inventors coming out of the Patent Office, to identifying the underlying causes of the gap, which Professor Swanson talked about a little bit already, between women and minority inventors in the Patent Office. Some notable items that were discussed sort of at length and were the subject of many comments that were submitted to the Patent Office was whether the Patent Office itself should collect data, demographic data on inventors and applicants to the Patent Office, as well as what actions the Patent Office should take to promote diversity in addition to the work that was already being done. There were also 3 public hearings that were conducted in San Jose, Detroit, and here in the DC area in Alexandria. So various entities submitted responses to the request for comment. There were, it was sort of a wide range of folks. We had the academia, Washington University in St. Louis, Facebook, so industry, IBM, other nonprofit organizations, as well as many different individuals, including Professor Matima, submitted information in response to that request for comment, as well as individual inventors who expressed concerns about holding on to their patent rights and what this act would do for those inventors. In addition to the request for comment, the Patent Office also heard oral comments from 36 people at the oral presentations. So what was the reaction sort of coming out of this request for notice and comment? One of the big issues that I think many different commenters focused on was the fact that there's already or seemingly biases potentially in the Patent Office examination of patents for some of the reasons that Dr. Swanson talked about, and particularly for women, where it's a little bit more apparent on the face of the application who is applying. The statistics had shown that between 7 and 21%, there was a 7 to 21% gap in the granting rates between men and women. And so there was a concern that if the Patent Office was actually collecting the statistics, that might be influencing decisions, or sort of, I think more pressing, give the appearance that it was influencing decisions on who was actually being granted patents and whether there were any biases playing into that process. So in response to the Success Act, though, I think nearly everyone agreed that we needed more data about who is obtaining patents and who is applying for those patents. And it really was just, how should that data be collected? Should it be collected by a third party? Should it be something that the Patent Office itself is administering or requesting in the applications? And what would the impact be? Would it have a chilling effect on inventors, a chilling effect on minority and women inventors in particular? There was also a recognition that the sort of tracking and statistical information that could be gained through this process and the Success Act really was sort of the end result, but that we have a more pressing issue, which is the pipeline issue. And how are we getting the minorities and women coming up through the science, technology, engineering, and mathematics fields to be able to position themselves to apply for and obtain patents? And what can we do to address that sort of fundamental problem? So now I'll talk a little bit about the Patent Office's report. So considering all of these comments, as well as the oral comments at the hearings, the Patent Office met the deadline, the October 2019 deadline, and issued a report of about 35 pages laying out its key findings on and some proposed solutions to recommend for legislation. This is the cover of the report that issued in October. It was issued in consultation with the Small Business Association, and the Patent Office, in sort of issuing this report, reviewed a large volume of literature as well as the comments and information that had been submitted. The cover of this report includes some notable inventors, minority and women inventors, including James West, who was an Army veteran with over 100 patents, including for the electronic microphone. Ellen Ochoa, the first Hispanic woman from the United States to go to space, who obtained 3 patents for optical systems. Marianne Rogers Croak, who has over 200 patents, including for the text-to-donate technology developed after Hurricane Katrina. Roy Cooper, an Army veteran who is paralyzed from the waist down and holds 25 patents, including for a robotic strong arm. And Frances Arnold, who won the 2018 Nobel Peace Prize in Chemistry and has 60 patents, including for enzyme evolution. So the PTO showcased sort of the wide-ranging contributions of both women, minorities, and veterans in the report, which I think is important in view of the discussion that we just heard from Dr. Swanson. Unsurprisingly, one of the key conclusions reached by the Patent Office was that women and minorities were significantly and had remained significantly underrepresented among both inventors applying for patents as well as obtaining patents in the Patent Office. These are 2 examples of charts that were reflected in the report. They show here on the left is a sort of the historical share of women inventors. You can see here that the share has kind of very gradually risen over between 1870 and 1940. And then the chart on the right is more current information from 1976 to the present. So in 1976, women made up approximately 3% of inventors on patents at the Patent Office. And the percentage as of 2016 was still only at about 12% for a population that makes up 50% of the population. So similar findings with respect to minority inventors, and in particular African American and Latinx inventors. The report sort of laid out a, not surprising, but I think somewhat disappointing picture for underrepresented minorities in the inventorship ranks at the Patent Office. Looking at the numbers, while African Americans make up 11% of the U.S. population, only approximately 0.3% of inventors were African American, according to the statistics that were relied on by the Patent Office. Similarly, for Latinx inventors, only approximately 1.4% of inventors were from this demographic group, despite the fact they make up 11% of the U.S. population. And so why is this, sort of stark finding important? And I think the Patent Office went into some detail about how this impacts, not just the inventorships of particular individuals, but society as a whole, as well as the inventor's life and sort of earning potential and all of those things. So the report found that in addition to sort of the prestige of owning patents and the respect that sort of comes along with that, there was a link between the patent ownership and intellectual property ownership and increased income, promotional opportunities, increased professional networks. Those were some of the sort of underlying issues that I think this gap is going to present and has been presenting over the past several decades between both women and minority inventors in the patent office. So this is just a chart, another chart from the report, which shows that consistently over time, individuals who have earned patents from the patent office have a higher earning potential than those that do not. So at the very end of the report, the Patent Office laid out some 5 particular recommendations at a very high level for legislative improvement. The first two really focused on how the Patent Office could obtain more authority to collect and report on data. So the first recommendation was that the Patent Office be allowed to collect demographic information on inventors in order to track these statistics more readily. The second recommendation was that the Patent Office be able to have access to other government agencies, perhaps the Census Bureau or other entities within the Department of Commerce, to be able to link up information that the statistics and data that the Patent Office tracks with information that's tracked by other government agencies. The third proposal was to expand the use of grants and other funds, but there wasn't any kind of sort of specific information about what programs those funds would be sort of directed to or driving. And then the final proposals were a little bit more symbolic in sort of recognizing that there's an important in sort of having a pipeline and promoting at the younger levels an interest in science, technology, engineering, and mathematics fields. So the report, was mostly findings and conclusions about the statistical evidence and the data that the Patent Office had collected from various sources, and largely left open the concrete steps that we can take to address the gaps in the numbers of women and minority inventors. One thing that I think is important to recognize is that the PTO tracking statistics really can only go so far. As the report acknowledges, there are significant societal, educational, social obstacles that are faced by both women and minorities to pursuing careers in the science and technology field and in those industries, as well as to obtaining patents and entering into the Patent Office and sort of gaining all of the benefits that flow from that. Despite the attention that's now being given to these issues, I think there's a lot of work that remains to be done in improving upon and developing the pipeline that of women and minorities coming through in these particular fields that would set them up to be able to apply for and obtain patents at the Patent Office. So to place the PTO's report into context, I think it is important to understand this current representation for women and minorities in these STEM fields, both in the higher education and in the workforce, and just sort of run through a little bit of the statistics here and some of the things that I think are, in addition to the institutional barriers that are driving a lot of the disparity here in the Patent Office. So this is just a report from the National Student Clearinghouse on Women, a research center, that women earn only 21% of bachelor's degrees in engineering disciplines and 39% in the physical sciences, so are still significantly, even today, underrepresented at the educational level in these fields. Similarly, in STEM fields for minorities, the National Center for Education Statistics reports that almost 2/3 of all STEM degrees are earned by students who are white, and that less than 9% are earned by African American students and 11% by Latinx students. When you move to the life sciences field, the split is a little bit better, but it's still, there's much work to be done in industry as well as in education. So I'll just sort of skip to, given the time to the end, on initiatives that we can do to promote diversity in science, technology, and engineering fields, and where we can go from here. So we could easily have a whole separate CLE session on how to promote diversity in these fields, but they're coming out of the notice and comment process, as well as through the reports and data that were submitted from industry. One of the critical things is educational outreach at the early levels and at getting to students at elementary and middle school to introduce them to these fields, to build a pipeline so that they have an interest in going into this area. In addition to that, I think it's important to ensure that women and minority students of color do not feel isolated in these particular fields. And you sort of coming from a mechanical engineering background myself, I know exactly how that feels, being the only woman, the only person of color in a room full of 40. So ensuring that there are professional organizations and support networks for minorities and women of color in these fields is critical to driving increased participation in the industry in these fields, as well as increased patent applications and obtaining of patents in this field. So with that, I will conclude, unless there's any questions for myself or Dr. Swanson. Thank you so much.
And so as promised, I'm going to steal a couple of minutes because we're close to the time that we need to move. But does anyone have a quick question or comment? Yes, way in the back. Yes. Oh, yeah, we got, oh, you know what? Let me get, no, well, yeah, just say it now and I'll repeat it.
Is that engineers don't know.
Yeah,
On? Okay.
just speak into it.
All right. So engineers don't know about patents. So I've been working with NSB. Can you hear me?
It's not a projection, just speak into it.
Oh,
Just
okay.
speak into it.
so engineers don't know about patents. So I volunteer with NSB. I talk to engineers all the time. I'm talking to, I'm going to NSB tomorrow at Johns Hopkins University to lecture to some engineering students. So all that is true that was just presented, but engineers don't know that they create patents. They don't know it until they get to certain companies. They don't. So the education is missing for engineering students, not just black students, white students also. But white students get the benefits of society in different ways than black students do. So the education is needed. So for patent attorneys, you have to go to the undergrad schools and teach the engineering students about patents, how they are, what they work, what the property is, what a patent is. People think they heard of a patent, they've heard of a trademark, but they don't really know what it is. So when I talk to students, I explain it to them. I'm an attorney. It's a piece of property. I relate it to your personal property, to your real property. It's property. So that's the education that's missing. And then for black students and black companies, they lack the capital. I mean, I have people come to me all the time, small inventors who have ideas. They can't afford the filing fee at the patent office. I mean, they can't afford the trademark fee, $275. So there has to be a redistribution of wealth in America. And we have to lose this concept of race, that there's white people and there's black people. There really isn't. That's a construct. We cling to it. We've been convinced that we're black and that we're white, but we're not. We're all just people here, and we all have problems, and we all have their solutions. We have to lose that. There has to be a redistribution of wealth. So endless IP, so one program, so for Nike. So Nike gets a lot of design patents. How much money has Nike made in the black community from basketball shoes? So if I can get a hold of Nike, if anybody knows Nike, I want Nike to sponsor, through my nonprofit, a design patent competition for black kids. They'd probably come up with all kind of fantastic designs. We teach them about IP, teach them about business, and then Nike could invest in those companies and go forward. So a lot of programs like that, but just education and then wealth. I mean, those two things together. That's not the only solution, but that's part of it.
Okay, thank you. Thank you.